Hello, everyone. Welcome in. This is what we've all been waiting for. In this video, we will be reading the full reply brief of the state. This is technically supposed to be the very last filing before the Supreme Court makes their decision. The defense has asked for oral arguments. I have not seen that the state has asked for oral arguments, so it is kind of up in the air right now as to if the Supreme Court will decide that these parties need to come in for oral argument on the matter, or if they will be able to make their decision based off of these briefs and the record proper. Before we jump into the state's reply, I wanted to read one page out of an amicus brief that was filed in support of Alexee. If you saw the very last video, we discussed that there was going to be some amicus briefs filed on behalf of Alexee, which essentially it just means they're not actual parties of the case, they're friends of the court, but they get to have their say and kind of try and sway the Supreme Court's decision on this. Well, this particular page really stood out to me. I've only glossed over these. Also, if you would like me to read these in full, I will be happy to go over all the amicus briefs. You'll hear from this page exactly the gist of what everyone's trying to say, and you'll also understand it from the point that I'm going to show you. So I'm trying my best to kind of consolidate the hooey, so to speak, because let's just read this and you'll see exactly what I mean. This is from a professor's song from the Police Accountability Project on behalf of Alexee. At first blush, the New Mexico statute would seem to give law enforcement access to any and all patient health information if the crime at issue concerns child abuse or neglect. Okay. That at first blush, it sounds like the state should have their information back. However, such broad and amorphous permission would render inapplicable large swaths of health privacy laws and the medical providers' duties of confidentiality and privacy for any patient suspected of child abuse or neglect. Well, yeah, that's kind of how they intend it. They don't care about their privacy health laws for people who abuse children. That's the literal exception in the law. So I'm just shocked that a professor is putting this into a document. Rather, they're like, this proves it up top. Yeah, the statute would seem that everything's fine. But that would mean that they could take all this information. Yeah, welcome to what police do. Sorry that it's affecting something you care about, but that's what happens. Rather than adopt this broad reading that would make health privacy and patient confidentiality protections largely meaningless, very strong claim, just because one person who possibly put a live baby in a trash had their information shared does not mean that all information is thrown out the window. If no possible crime had been committed, then the hospital wouldn't have been allowed to do this. So when they say this is just going to blow the roof off the place and blow the door wide open so that everyone can just have their privacy invaded is not true. So rather than adopt this broad reading that would make health privacy and patient confidentiality protections largely meaningless, a thorough and contextual analysis of medical providers' legal and ethical obligations point to the opposite conclusion. Okay, namely that the exceptions to the disclosure provisions in HIPAA, which has been conceded basically by both sides at this point, that is irrelevant in this case. It's a civil remedy. It has nothing to do with a criminal case. So HIPAA doesn't matter. But again, this professor of criminal law decided to put it in a brief going to a Supreme Court. I mean, that's crazy. To the disclosure of HIPAA and the mandatory reporting obligations imposed by New Mexico do not result in the wholesale production of patient information and evisceration of patient confidentiality or privacy protections. Medical providers should not wholesale disclose information to law enforcement, but only information that is necessary for law enforcement to begin their investigations. Interesting. Because it's kind of what we've been saying they did with Alexee over here. We're didn't they just begin their investigation? That's all, and they're allowed to do that. The contextualized reconciliation of the applicable laws and ethics is not just correct, it reflects a balancing of the respective goals of public safety and patients' rights. In the instant case, by the time Ms. Trevizo made the statements at issue, the mandatory reporting to police under New Mexico law had already been made. And then they started their investigation, like you said up above. The police had arrived in response to that reporting. The reading that best comports with New Mexico law, federal and state health privacy laws, and the ethical principles governing medical providers is that the mandatory reporting requirement ended at that point. Mandatory reporting statutes are meant to help police identify when a crime has occurred, okay, and to give police relevant information that the medical provider is aware of at the time of the report. Okay? It is not meant to help police build an evidentiary case of the suspect or against a suspect. But they're kind of glossing over the fact that the relevant information at the time of the report did eventually help build an evidentiary case, rightfully so, for a homicide, right? This isn't how these people, I think, were sold this. I don't know if the people on behalf of the defense were ever sent the autopsy. I don't know if they looked at the autopsy. By the way these arguments are going, I don't think they did. That's just my opinion. Because I'll show you on the next page. Let me go find it here. So this is the amicus of the College of Obstetricians and Gynecologists, focusing in on point number 2 here. Criminalizing pregnancy outcomes is inconsistent with expert consensus, harms the clinician-patient relationship, worsens maternal health outcomes. I don't think basically any of this applies to Alexee. Not only her maternal health outcome was fine. She, we all see the prom picture. She's happy, healthy, fine. Went back to her cheerleading, all that. She was completely fine. Criminalizing pregnancy outcomes is the big deal here. This is why I say I don't think that these people saw the autopsy, read the autopsy, took the autopsy into consideration at all, because how can you say that this was a criminalized pregnancy outcome? No, the outcome of the pregnancy is not what's criminalized. The putting the baby in a bag and not telling anyone about it is what's criminalized, unless that's what you're advocating for, right? So these briefs are a little bit dangerous, in my opinion, for these people. It's not a good look. These are really not great arguments in light of the facts of the case. This isn't a woman who did have an emergency that resulted in the possible loss of a child in a state with extremely restrictive abortion access. And if someone suspected that she had an abortion and they're criminalizing her without due process and the probable proper cause, then or probable cause, I need to see that. I need to see an actual criminalized pregnancy outcome for these arguments, not someone who had all reason to believe that the hospital would help her at that point. I mean, the doctor was actively trying to figure out what was going on with her and knew that she was pregnant now and was setting up a pelvic exam to try and figure out to the best of her ability how far along Alexee was. Alexee wrapped a baby in a plastic trash bag, concealed it under a fresh trash bag so no one would see it for an extended period of time, which implies murderous intent, because if someone found the baby in time, they could have saved the baby's life. So there is a lot that implies that this was not a criminalized pregnancy outcome, yet the College of Obstetricians and Gynecologists have put their name on this. So very interesting to me. We have saved all the good news, all the best for last. Let's finally go into the state's final reply brief. Everything has finally come to a head in this case. Before I have the privilege of reading you this document, I would like to take just a very quick second to say thank you to everyone from the bottom of my heart who's been here all along the way. I hope that the very first sentence in the state's reply brief brings everyone some solace and hope. The one true victim in this case is baby AF. Was born in a hospital bathroom to his mother, defendant Alexee Trevizo, in the early morning hours of January 27th, 2023, before being placed into a bag in the trash bin, where he remained until discovered by hospital staff at least 30 minutes later. Defendant asserts that 1, she was in police custody and subjected to interrogation, and therefore the Miranda versus Arizona advisement was required before her statements could be used against her. 2. Medical staff, primarily Dr. Vasquez, acted as an agent of the police, and their interrogation is imputed to the police. And 3. There was a violation of the physician-patient privilege under Rule 11504 NMRA. However, the record and the applicable law shows the defendant was neither in custody nor interrogated by the police. There was no interrogation by medical staff, and the record contradicts the defendant's assertion that the medical staff were acting as agents of the police. Defendant's mother conducted the only substantive questioning. Additionally, the physician-patient privilege did not apply because of the reporting exception rule in 11504D4. The suppressed statements cannot be described as confidential within the meaning of Rule 11504A5 because they were not made, quote, privately, i.e., they were uttered in the obvious presence of police officers. As a result, even if the privilege applied in the first place, which the state denies, the privilege was waived by making such statements in the obvious presence of third persons, whose presence was not needed in support of any physician-patient purposes of the communication. Simply put, the police and medical staff properly performed their respective duties. Despite that, defendant mistakenly posits that the medical staff were somehow acting as agents of law enforcement. The fact that police and medical staff treated each other respectfully, honoring their different functions, just as they treated defendant courteously, does not transform the relationship between police and medical staff into a principal-agent relationship in either direction. The state does not further address HIPAA because defendant does not materially rely upon it in her brief. HIPAA's out the window, guys. Supplemental summary of proceedings. It is natural that some factual disputes exist at this current pretrial stage. However, because of assertions set forth in defendant's brief, many of which are unsupported, the state supplements the summary of proceedings with additional material here. Defendant claims that due to medical malpractice or otherwise, the victim, baby, was dead at birth. The state chose not to discuss the evidence bearing on the cause of death in the interest of brevity and because it was not directly relevant to the issues in this appeal concerning pretrial evidence suppression. A preliminary examination found probable cause for the charges with respect to which defendant raises no issues. However, even acknowledging the pretrial nature of this case, some mention of the medical-related testimony from the preliminary examination is warranted given numerous assertions in defendant's answer brief. At the preliminary exam, a forensic pathologist from the Office of Medical Investigator testified in detail that the baby, which had no injuries or defects, died as a result of entrapment from being placed in a garbage bag in which the oxygen was eventually depleted, and that the manner of death was homicide. Although a jury has yet to resolve factual disputes, defendant's answer brief omitted any reference to that forensic testimony, which is clearly contrary to her claim that the baby was dead upon being born. Defendant's answer brief also contains a broader thematic element attempting to blame the death of the baby on the medical staff. For example, defendant asserts with no relevant record citation whatsoever that Dr. Vasquez prioritized a police interrogation over a medical transfer to another facility, appearing to suggest that medical staff purposefully delayed that transfer. Such a claim is not only unsupported by, but affirmatively controverted by the record, Because defendant failed to include any detailed transcription of the police lapel video bearing on her assertions, the state will discuss what occurred in more detail here, because it will also confirm this court as to some of the Miranda aspects. Let's roll up really quick here and just look at this note. As a result of defendant's failure to include any reference to such testimony, the state filed on October 30th an unopposed motion to supplement the transcript with the audio from the May 16, 2023 preliminary examination held in that concluded but related case. The court granted this motion on November 12th, 2024. So that is basically what we read at the very end of the defendant's response. We were prepared that they were not really happy with this stillbirth argument as far as the state. And so they filed that and it was granted. So the Supreme Court is looking at the autopsy to disprove a lot of the things said in the defendant's reply brief. Like, a lot of that gets kicked to the curb because they're arguing off false premises and premises that the fact finder gets to find out and to decide, and so very interesting, very interesting. We can continue here. As noted in the brief in chief, the doctor told the police at 2:41 a.m. that defendant had been accepted at Loveless in Roswell and needed to be moved there quickly. The doctor noted that she still needed to tell defendant what was going on, implicitly referencing that she needed to obtain defendant's consent to transfer her. Without prompting from the police, the doctor asked if one of the officers could be present in the room. Police did not tell the doctor what to say because some nuances are not captured by even an accurate summary. The state sets forth the exchange, which occurred immediately after the exchange set forth in the state's brief in chief. Doctor, number one priority, guys. Number one priority. She just had a baby. I don't know if she delivered the placenta. She's bleeding significantly. I've spoken to the obstetrician at Loveless and they want her up there as soon as possible. I just need your permission, looking towards defendant's mother, to transfer her for medical. Charge nurse, she's 19. Doctor, oh, you're right. Mother, but she is a student too. Charge nurse, she's still 19 years old. Doctor, you're right. I forgot she's 19. Defendant, unintelligible, ... came out of me. Doctor, you need to make sure you're safe, I need to send you to Loveless to labor and delivery. Will you please agree to that? Defendant, yes, I agree. Okay, I'm going to work on that. I'm sorry about this, but in terms of delivering a baby and it looked like you tried to hide it, we do need to have the police involved. Unintelligible, nothing was crying. It came out with nothing. Doctor, I know, but the baby is going to have to be taken for autopsy and there will be an investigator and everything. I'm sorry. I'm so sorry, but we need to do this correctly. I want to be transparent with you about what our steps are going to be. Slight pause. Officer, do you guys need to talk to her before we get her transferred? Sergeant, how long is it going to be before you have the transfer out? Doctor, I don't know. Unintelligible. Maria, what do you think? 20, 30 minutes? Maria, yeah, hopefully yes. Okay. Sergeant, I've got a detective on the way, so they're going to be talking to her. Doctor, okay. Doctor leaves. Charge nurse, I'm the charge nurse here. Do you guys have any questions for me? Mother, like how big is the baby? Charge nurse, it's full term. Mother, what? Defendant, nothing. Mother, overtalking her. 9 months? Defendant, nothing, was crying. Mother, Lexi, have you watched the news of the girls, that what they do to their babies and what they go to jail? Defendant, nothing, was crying. The police did not ask any questions of defendant during that time, and the doctor, as seen above, was expressly concerned, justifiably, with defendant's medical well-being. Following that exchange, as noted in the brief in chief, the police told defendant that a detective was on the way and that she would be detained 2.5 and 3 minutes, respectively, after the doctor and police entered the room, despite defendant's claim that the officers remained in the room until she departed for Roswell. The officers waited in the hallway for most of the time between about 3 a.m. and when she departed via helicopter. That is evident from Sergeant Anaya's lapel video, showing that he later stepped into the room in which only defendant was present, present from the hallway and told defendant that they would continue to wait in the hallway because they did not want to add to her stress given the situation. Defendant also implies that officers, despite having already told her she was detained and her status as a 19-year-old adult, somehow improperly isolated her from her mother while waiting for the detective. However, it is clear from the video that the officers quietly talking in the hallway viewed the mother as unduly adding to defendant's stress. One officer noted that he had to previously tell the mother to stop aggressively questioning defendant, referencing the mother's, quote, yelling earlier. Additionally, the fact that the helicopter's arrival was apparently later than initially expected is immaterial. Defendant noticeably fails to allege that medical staff or the police negatively influenced the helicopter's arrival time. We'll read this little subnote before we go on. Given the discussion transcribed above, which occurred around 2:45 a.m., the helicopter was initially expected to arrive by about 3:15 a.m. The record is clear the defendant was loaded into the helicopter at 4:30 a.m. Although the record does not reveal exactly when the helicopter landed outside the hospital, it is reasonable to estimate, given that it is not an essential fact needed for purposes of resolving this pretrial appeal, that the helicopter landed sometime around or even after 4 a.m. in light of the time presumably needed to ensure some coordination between the helicopter crew and the hospital staff prior to defendant's departure. Back up here so we can continue. Crucially, the record fails to support defendant's bare assertion that police or medical staff were, quote, prioritizing an alleged interrogation over a medical transfer. There is no evidence to suggest that anyone caused any delay in defendant's medical treatment or transfer, which occurred prior to a detective's arrival. Defendant's claims of medical malpractice starkly contrast with her failure at any point to assert, even at the hospital, any basis explaining why she was unable to call for help from the bathroom by simply yelling out that she was having a baby or had just given birth and needed help. Defendant observes that Dr. Vasquez did not attempt resuscitation of the baby, but fails to note that Dr. Vasquez testified that the baby found at least 30 minutes after it was placed in the trash bag was cold and had no pulse, and accordingly, no resuscitative efforts were made because there was no hope of reviving the baby. Defendant may be found criminally liable independently and apart from issues of alleged medical malpractice, which must be resolved in a civil proceeding, and this court's focus should not be improperly drawn to such matters. Argument. Number 1, the district court erred in suppressing all statements made by defendant who was not in custody and not subject to interrogation. Defendant asserts that she was in custody and was interrogated, although she contends she was interrogated by the doctor she characterizes as an agent of the police. However, the material fact and relevant law establish that defendant was neither in custody nor interrogated. Defendant asserts that she was in custody because, quote, several adult authority figures blocked the exit to the room. Despite that, defendant was 19 and was an adult. Related to this, defendant notes that the charge nurse, who was also present, had shared his concerns with the police. Similarly, defendant relies indirectly on an officer's having written in his report that he stood by the doorway to ensure that defendant could not leave. However, nothing in the record suggests that anything the charge nurse said to the police or anything written in a report was known to defendant, nor does she claim otherwise. Subnote. A civil lawsuit has been filed. First amended complaint, Bustos versus the Artesia Special Hospital District, asserting malpractice claims against medical staff and hospital on behalf of the estate of the baby. Defendant's numerous references to alleged malpractice unnecessarily divert attention from her actions as the mother of the baby, particularly considering the limited legal issues in this pretrial appeal. Bang. Sorry, I'm trying not to react too much, but wow. Okay. As previously noted, information not known by the subject is not relevant to the custody determination, meaning if Alexee doesn't know about it, it doesn't impact her. The state agrees that various factors may be relevant in a particular case in determining whether a subject had a reasonable belief that they were in custody. However, the mere presence of police officers is not sufficient to constitute custody, yet that factor was the primary, if not nearly exclusive factor upon which defendant relies, and which appears to have been the primary factor underlying the district court's ruling. Well-reasoned decisions have correctly concluded that the presence of police officers questioning a subject in a hospital does not, without other factors, equate to custody. See State versus Garrison. Noting that the tone and tenor of questioning in a hospital weighed against the conclusion that the subject was restrained to a degree associated with the formal arrest, despite that subject was questioned by 5 police officers. As here, the police in Garrison did not cause any delay in treatment or hinder medical staff, nor was there any evidence that medical staff were acting at the direction of law enforcement, concluding that nothing suggesting that a reasonable person would perceive the officers to be exercising any control over the medical staff. And the record actually demonstrated that officers exercised no such control, nor did the officers delay or hinder medical care. Likewise, there was no, quote, police-dominated environment in this case, State versus Spielman v., noting that custody involves a, quote, police-dominated situation. Garrison observing that not all restrictions on a suspect's freedom of movement rise to the level of custody, and that the concerns focuses on whether it was a police-dominated environment. Defendant tries to distinguish Munoz, but the fact that the subject in Munoz was told that he did not have to go with officers or talk to them does not materially distinguish this case from the underlying principle of Munoz in similar cases, which is that the presence of police officers is relevant but not determinative, because it is not alone sufficient to result in a finding of custody. Defendant made statements despite clearly observing the police and before being told nearly 3 minutes later that she was detained. The police did not say or do anything that would cause a reasonable person in defendant's situation to believe that she was in custody prior to making her statements. Footnote. Defendant notes that the officers were armed, a fact that is of no substantive consequence. It is common knowledge that police are armed. And there is not even a suggestion that the police emphasize that fact in any manner whatsoever. Those little subnotes are just awesome in this. Defendant cannot logically claim that because she later found out that she was detained, her prior statements were inadmissible. The suppressed statements, which were not even the result of interrogation, occurred before defendant was told she was detained, and no material facts known to her prior to that point or even after, would have caused a reasonable person to believe that she was in custody. Noting that subject, Ybarra, that's the one that's been referenced a lot, noting that subject was in custody because he was, quote, placed under arrest before being taken to the hospital. Defendant also asserts, largely relying upon State versus Santiago, that she was subjected to interrogation by the police through Dr. Vasquez, whom defendant describes as the conduit. In Santiago, this court found that private security guards' unilateral action of searching a suspect for evidence could not be attributed to the state. Santiago adopted the federal formulation for analyzing whether conduct performed by a private actor could be imputed to the police, but expressly noted that the court was open to further refinements. However, this case is similar to Santiago, in which this court concluded that mere awareness of a private party's actions fell short of establishing an agency relationship and was nothing more than speculation. Number 5 and 6, as previously noted, being, quote, detained does not necessarily render a person subject to custody for Miranda. The state agrees that the basic analysis of Santiago has been applied in the context of Miranda. First, there is no evidence that the police and doctor agreed or conspired to interrogate defendant through the doctor or otherwise. Further, as to the second factor, defendant has offered no evidence that the doctor was not naturally motivated in part by professional medical concerns, i.e., concerns related to her own ends, in attempting to ascertain for practical, legal, and other reasons what happened to a baby in the department in which she worked. Noting that even if a private citizen is motivated to both assist government and to further his or her own objectives, that private citizen is not acting as an agent of the government. The lack of either Santiago factor is a dispositive of a defendant's attempt to impute the doctor's actions to the police. As a result, it does not matter whether the statement initially made by the doctor would have been the functional equivalent of an interrogation had it been stated by the police, because there was no agency between the police and the doctor. There was no interrogation. Defendant's reliance on Ybarra is misplaced because Ybarra involved custody and interrogation, each of which is missing here. No evidence, and certainly no substantial evidence, supports the district court's finding that Dr. Vasquez acted as an agent of law enforcement. Further, as seen in the video portions transcribed above and in the brief in chief, no evidence supports the district court's characterization of the doctor as being, quote, confrontational. In a nutshell, I love that. In a nutshell, defendants claim that the doctor must have been an agent of the police because the doctor allegedly prioritized the investigation over medical concerns has been shown to be false. Further, it was defendant's mother who was asking defendant questions. There was simply no interrogation here within the meaning of Miranda-related case law. The district court erred in suppressing all statements made by defendant based on the asserted physician-patient privilege. Defendant asserts that her statements are inadmissible due to the physician-patient privilege. However, defendant fails to squarely address the express language of Rule 11504D, which demonstrates that it does not apply here in the first place. Rule 11504D lists exceptions to the privilege, one of which is as followed. Required reports. No privilege shall apply for confidential communications concerning any material that a physician, psychotherapist, state or nationally licensed mental health therapist, or patient is required by law to report to a public employee or public agency. Let's read number 7 down here. And just for a moment, I will tell you, when I read this, I was so extremely excited. On this channel, we have basically characterized what this point 7 down here, this little subnote, is. We've said this multiple times. I've called it the off-the-wall theory, the off-the-wall, legal argument in this case. And we even mentioned it as far as the very last video at the end. It's like she wasn't being honest with the hospital staff, so how is the privilege even applying anyways? Because the express language in the privilege doctrine here is saying that its main purpose is to encourage a patient to be honest with their physicians, and that violating this privilege could incite people to not be honest, and that could really impact people's health. Now, point 7 here. Defendant also squarely fails to address the state's argument that even if the privilege could apply, despite the express exception in Rule 11504D and the clear circumstances of waiver, it depends on the patient being reasonably honest with the medical staff, a fact woefully lacking here, including particularly at and after the point of birth. So everyone, y'all heard it here. We have been saying this, that the privilege shouldn't really even matter because she wasn't being honest with them. And that's what the whole point of privilege is. And Alexee was flying in the face of medical privilege, but now wants her statements to be suppressed and to be privileged and to be held sacred unto Alexee. No, that's not how it's going to go. And to see that argument not listed as a full argument, a subpoint, but that's fine. But the fact that this made it into the Attorney General's filing, this was the Attorney General who wrote this. This came from the Attorney General's office because it is going to the Supreme Court. And, like I said, oral arguments and this whole process is different than trial and trial attorneys, usual proceedings. So when it comes to this was extremely exciting to see. I'm sorry to distract us from here, but you guys, we've been saying this. We said it from the very beginning of reading Rule 11504. I've said, oh my gosh, if I never have to read this again in my life. I've read it so much. And I really was worried about the evidence in this case because the defense came so strong. So I really had to study the law around this when the case first broke so that I could be confident for all of you as well, because I don't want to sell you up the river if the law was really on the defendant's side. And when reading 11504 until my eyes were dry, I stumbled upon this exact thought, and we presented it here. And we said at the very end of last video, saying like, man, if she was only being honest, that's what the whole privilege would be. Like, I think the privilege is thrown out the window because she wasn't being honest with them. But that's just how I see it. I understand it's kind of an off the wall thing. It also draws a conclusion that we're like drawing the conclusion that she was never honest with them. But according to all the witness statements, she wasn't. So, sorry to take such a big pause there for that. But that was extremely exciting to see because it was our off the wall theory here. We didn't know if this would work, but hey, look at it being in this pleading. I can't believe it. Rule 11504D4, bold emphasis added. Given the express exception in the rule for what would otherwise be confidential communications, the privilege must be construed in light of any applicable mandatory reporting law. The physician attending to defendant was required to report the discovery of a newborn under NMSA 1978. Every person, including a licensed physician, who knows or has a reasonable suspicion that a child is an abused or neglected child shall report the matter immediately to authorities. That duty to report is meaningless if it does not include the duty to report a full term, apparently healthy newborn baby found in a trash bag in a hospital bathroom. Defendants claim that there is no overriding public interest in investigating the death of a deceased but otherwise apparently healthy newborn baby in a hospital of all places. Defies logic. Defendant also claims that she did not waive any privilege, even assuming the privilege applied in the first place. Defendant misconstrues the state's point, which was that defendant cannot avoid waiver by asserting that police were merely acting as security agents of medical staff, which might otherwise prevent an interference of waiver. Despite defendant's assertion, the state never argued that police were there merely for security. Defendant also asserts that the state cannot have it both ways, citing Salas for the proposition for which the state cited it. The state's assertion was diametrically opposed to the manner in which it is now characterized by defendant. The state correctly observed that the disclosure of information to or in the obvious presence of third parties, not necessary to further the privilege at issue, waives or vitiates any such privilege. The state had further asserted that this was, quote, not a case in which police officer can be viewed as merely an agent of the physician, such as when police are there merely for the physician's protection, in which case a defendant might otherwise avoid finding a waiver. That the police were there investigating a potential crime does not prevent the application of the doctrine of waiver within the context of the physician-patient privilege, just as the fact that the police were investigating a crime does not entail a finding that defendant was subjected to custodial interrogation. I just love this. Let's read point 8 here. Similarly, defendant asserts that the state relied on a case, People v. Salinas, to support a contention that the doctor sought police presence for her own safety. Yet a cursory examination reveals that the state cited that case at the point for the basic proposition that a physician does not become an agent of law enforcement merely because the police are visibly present while the physician interacts with the patient. Defendant appears to have confused the issue of alleged interrogation with the issue of waiver of the physician-patient privilege, which, if you remember in the reading of the defendant's reply, I was confused at one point. I got extremely confused because I'm like, who said this? Like, no one said this ever. And so that addresses it. They were basically saying all this hubbub about the doctor, if a doctor has someone be a bodyguard for them, that they're, like, that the police officer is now part of, that they're working in connection or whatever. And I was like, no one even said they needed a bodyguard. No one felt threatened. Like, that has nothing to do with this case. Was not why it was referenced at all. And so they're saying literally they confused it and just like ran with it in the complete other direction, which is just like, luckily it seems as though none of these people are being paid to do any of this legal work from the stuff I've been able to obtain. Like, all the money's gone to the expert, Chris Scary. His name's Chris Sperry, but Chris Scary, the expert for Alexee, that's where all this money's gone so far, is from what I can tell. So all this is free legal work that was done on the defense's part, essentially. And so, it's you get what you pay for. It's in some senses, and this might be one of them. So they completely ran the wrong direction with that. Sorry, we'll keep going. Defendant has failed to rebut the obvious truth that the presence of third parties here, the police and defendant's mother, waives a privilege. Defendant's mother was not needed to provide medical care. Defendant was age 19 and 2 months at the time. Rule 11504A5 itself provides that a communication is not, quote, confidential if not made privately, i.e., if it is disclosed to others or made in the presence of others, when such disclosure is not in furtherance of the purpose of the communication. Just as there was no evidence that the medical staff were acting as agents of the police, there was no evidence that the police were acting as agents of the doctor or other medical staff. I cannot believe that this is written out like that, because that's literally what they were trying to say. Remember when we're like, they're magically becoming a doctor and magically becoming a police officer? Like, their arguments were just all over the place. And so it's just so funny that they had to put that in the defense. And the police weren't acting as agents of the doctor either. So, like, no one was acting as anyone's agent for anything else. This was all just an investigation into, hey, why is this baby thrown in the trash? Everyone's allowed to be doing what they're doing in this situation. Okay, sorry. Accordingly, defendant waived the privilege even if it applied in the first place due to the obvious presence of third persons. Rosa, you done messed her up. Rosa. Conclusion. Defendant was not in custody, nor was she interrogated. Accordingly, Miranda was inapplicable. Additionally, the physician-patient privilege does not apply here to prevent admission of the statements for the reasons set forth in the brief in chief and this reply brief. The state asks that the court reverse the district court suppression order in all respects and remand this matter for further proceedings. Like I said, Raul Torres, Attorney General, Michael J. Thomas, Assistant Solicitor General. So this was the full reply of the state to the defense. Now we still have the state's initial filing to go over. Before, I did not have it. I do have it now. So we will be able to see what the state initially said, and that one's one of their longer documents, which brings us to the next thing I want to touch on very quick here about the length of all these documents. So if you look here, this is a breakdown by how many pages essentially all the actual brief filings were. There's a whole bunch of, like certifications for all the people who are out-of-state attorneys on Alexee's side and all that. Well, the state, their original brief in chief, which I have and I'm going to present to you, I just am doing a little bit of extra side research because there was a lot of interesting information about how the judge made the decision. And I want to make sure I can fully present to you some substance behind what the state was saying with that. And so we'll get there. They have this 17-page reply brief, which with a total of 61 pages. The defense had their 51-page response brief and 79 pages of their briefs from all these people who are in here on Alexee's side, with a total of 130 pages. Now, technically, this 130 pages from the defense was in response to the 44 pages of the state, and all the state took to respond back to that 130 pages was a 17-page reply brief that we just read. So essentially, the defense has put forth 69 more pages than the state in total as far as their arguments. Most of that is coming from these briefs over here, but that, aren't from her actual attorneys. Either way, I think this is a clear example of quantity over quality, where the defense has put out a mass quantity of information to the Supreme Court, but the quality of that information is extremely low. We read it live here. That was my first reading of that. I had read this document before, but that was my live reading of it. I hopped on here as soon as I could to read that with everyone. And so I was able to read this one. It was only 17 pages, so I was able to read it pretty quick and then hop on here. I was very excited to share this reply with you guys, because I know that the last one was extremely disheartening for most of us who do think that the facts are pretty clear in this case. We find the hospital staff to be victims of Alexee's actions. I don't know if I'm speaking for everyone, but I do feel like they were victimized by her, as evidenced by when you see on the hallway hospital footage, like the doctor literally hugs the janitor. The janitor is shook up, like she is very distraught. Everyone's distraught. As soon as the police officer, this one's on the body cam footage now, but as soon as the police officer comes out of the room asking the hospital, the janitor, what happened, the CNA standing outside the door, and she just looks so distraught. And so everyone is very distraught by what they just saw and what they just witnessed. And as they're piecing together the fact that they were, taken advantage of and lied and manipulated to, and they deal with medical emergencies and trauma and stuff like that. They don't deal with murder. Okay. Hospital staffs aren't infallible to being impacted emotionally by this. And I would say that they acted so professionally and heroically in the face of when they could judge Alexee, and they didn't. And so I commend the hospital staff for what they did. I truly think it's disgraceful how much blame is being thrown on them, how they're being used as a scapegoat, in my opinion, for the actions that Alexee took that night. The defense, their whole argument relies on the autopsy. With or without these statements, if the jury believes the baby was alive, it's very hard to convince them that Alexee thought the baby was not alive. And if all the statements are suppressed, guess what happens legally speaking? If all these statements stay suppressed, the defense can't pick and choose to re-enter statements made by the defendant, which means Alexee's initial statements, her initial alibi, if you were to just clip it out and say nothing was breathing, and you can't play that for the jury as the defense. So they are going to have to work without knowing Alexee's alibi. If all this was suppressed, her alibi from the very beginning is also suppressed, which I've always thought kind of is interesting for the defense, because Alexee's story hasn't changed. It's going to be what's on the polygraph if admitted. It's what's going to be, played on this video if this is admitted. And it's going to be their whole defense is that Alexee didn't know that baby was alive. With all the signs in the autopsy that the baby was clearly struggling to breathe, I do think that it's going to be very hard to believe that Alexee didn't know that, especially with the fact that she never told anyone that she had a baby. That's not going to be privileged. Like, that exact fact will still be able to be testified to no matter what. Were you ever told that a baby was born in the hospital bathroom? No. Every witness will have the same answer. So we're going to pull this out one way or another, but I don't think it's going to be that hard. I do truly think all this is going to come back, because those 17 pages really threw the gauntlet down. It really is saying these arguments crisscross and weave, and they don't make any sense, kind of like we've been saying here, that the doctor can't magically be a police officer and the police officer is magically a doctor, and all of this works to just specifically try to make any kind of argument that you can to get rid of this. As I alluded to before about the state's original brief in chief, we will go over it. I did imply that there is some interesting stuff about the judge, which, if you've seen how quickly these arguments have been formulated, how they've been presented to the Supreme Court, well, why did it take the judge so long to come up with that decision? There's a lot of interesting stuff surrounding that, and I have to be very careful what I imply. I have to go off the facts. So that's why it's taken me a minute to bring you the brief in chief. But because there is a lot of interesting facts surrounding that, and I always want to come correct with everything that I present to you, even if it is only implications. I want to have a lot of stuff to back up the implications and the things that I'm seeing and other people are seeing that just don't really add up and are sus to people. So there is a lot of hope on the home front right now that, you know, the higher legal minds of the Supreme Court are the ones who are analyzing this issue. And I know for a fact other states, not just New Mexico, but many, many states have written into their laws, they've taken account for having police officers investigate in hospitals. It's not this part of society that is just deemed off limits to investigation. Now, there are limits to police investigations via what hospitals know, but it does not cover and preclude any and all things ever done or seen or heard or investigated inside a hospital. That's just not how it goes. In that case, we've made this joke here before that based off the judge's decision, in this case, the one who suppressed everything, if I was a criminal, let's say I was a drug dealer, I would have all of my big time deals meet me at the hospital. They'd come in to get my care with me, just how Rosa was in there with Alexee, and then we would exchange our drugs and monies, and no one would be able to say anything. We'd go in the bathroom, exchange drug and money with each other, come out, and people would be like, I think they did something weird in the bathroom, but I don't know, and I can't tell the cops because it's a hospital. So what is really the line of right and wrong? It's the defense being hopeful that they can cover up what happened in this case. And they are so very upset at all the vast amount of evidence that was gathered immediately after the alleged crime. The police officer showed up in a record amount of time, minutes after the baby was found, and the phone calls were placed to 911. They were already around, oddly enough. We showed here in our video about Rosa being the star witness in this case. The police officers actually heard Rosa come out of the hospital room and ask for Alexee to go to the bathroom and be unhooked from the IV. For the moment that this all happened, that we see Alexee run down the hallway and go to the bathroom, deliver the baby, and not tell a word to anybody, not tell a soul, not say anything about it. That's literally such a crazy full circle moment that the police officers were actually there and they were still close by. Obviously, when this actual 911 call was placed, probably about 40 to so minutes, 40 to 50-ish minutes after Alexee went to the bathroom, right? Once the baby's actually found or whatever. So it's just wild that we have all of this, and that's why the defense is extremely upset. The police could have taken forever to get there. The doctor could have had less time, or more time to go in and have to confront Alexee with this, have that explosive moment between Rosa and Alexee, all off body cam. But that's not the way it went. The way of the world decided that the police were going to show up in record time and be present for that conversation, which they're allowed to be present for. And so when it comes to that, that's why the defense is so mad. This all could have been avoided if the doctor had went to Alexee first before trying to get her a transfer. But what would the point of that been? To tell Alexee, I think you're dying. I think you're bleeding out to death. Like, I just found this baby. No, she immediately went into action to save Alexee's life. And doctors often, at least in my experience, try to come with a solution before they just give you a prognosis. They know what they're going to do about it. If it's something that can't be treated there, they refer you to someone else. They don't just come in and be like, yeah, you're going into congenital heart failure. I can't really do much about that, though. No, they literally will be like, and this is who you're going to go see tomorrow, now, whatever, right? Depending on what how serious your issue is. They don't just come in your room and be like, you're dying. That's kind of what they wish would have happened to Alexee. We just found a dead baby and you're bleeding. All the stuff that basically could have been told to Alexee But the doctor would have had no recourse, no way to help her, and just been telling her bad news without any life saving measures being in place. And I don't think that's the way the doctor should operate at all. So I do think that the doctor was clearly within her bounds. And the defense is just really upset that the detectives, or well, just regular police officers, the detectives came way later, but that the police officers made it there so fast to get these statements captured on body cam, and a non-investigate or a non-interrogative, admission made by Alexee is not even really what is the issue here. What the defense really wants suppressed out of the whole interaction caught in the hospital room is Rosa's statement when she says, "I just asked you to tell me the truth." You see, the defense has, put forward this idea that Alexee was never told she was pregnant. First and foremost, we must say that that is an irrelevant argument. She knew she was pregnant once the baby came out. So I don't care who told her or who didn't tell her. Mute point, move on. But in the same vein of that point, is it really possible that before being confronted with the birth of the child after the child had been found, that Alexee was being confronted about being pregnant by Rosa? Because why would Rosa say, "I just asked you to tell me the truth"? Why did Rosa not think she actually had back issues and constipation, like Rosa told the police later on that night? I mean, Rosa's the one who showed up to the door 42 seconds after Alexee went into the bathroom. But hey, that's just my observation. That's the statement, that one statement that proves Alexee's intent. Because no matter what, Alexee was given the opportunity before the doctor came into that room with the police officers to have admitted to the pregnancy and the birthing of baby Alex in the bathroom. Her mom was clearly suspicious, thinking something is going on. Who knows how long that suspicion had been had by Rosa? Is it possibly the reason that they were at the hospital in the first place? We need this statement to open up a serious line of questioning about this for Rosa on the stand. She's already going to be grilled. And she's technically not subject to the privilege, but she's been lumped into it because she was present for the whole medical conversations that happened in their entirety. She was in the room the whole time, according to Rosa. So she knows every conversation that happened. We need to know the ones that happened between her and Alexee, not the ones between her, Alexee, and the doctor, because Rosa said, "I just asked you to tell me the truth." Not we, not us, not they, I. And Rosa's not subject to any kind of privilege. So I really would like that statement back in, because it is going to suck for Rosa on the stand to have to explain that situation, that conversation, why she said that. It's going to be a very hard moment for her. But she's the one who said it in the moment of being confronted with the news of a baby in the trash. She's the one who said, "I just asked you to tell me the truth." And I believe the jury is owed an explanation as to what exactly she meant by that. What truth did she ask her to tell? When? In what words? I have rambled on for far too long. My apologies, but I am extremely pumped up about this reply. I will say that it has long been said here on this channel, justice for baby Alex. And so I was so extremely happy to see the beginning of the very first line of the state's reply brief that says, "The true victim in this case is baby AF. So we can move forward with a little bit of hope and stay steadfast in the fact that we know that facts override these petty complaints, in my opinion, that have been put forth by the defense about the evidence in a case where someone was able to look a baby in their face and put that baby in plastic trash bag, hide that trash bag, and not tell anyone about that baby or try to get that baby help. Do I have to say that's my opinion, or is that facts? So I just, this is pretty appalling when I show you the people who put their name on these amicus briefs. I'm very dismayed, and I think maybe they're a little bit misinformed, but hey, again, that's just my opinion. I'd be a little wary to put my name on something with the facts as they are in this case. But hey, I'm just Lily Paralegal Online, and these are just my opinions. With that, thank you so much if you've made it this far in this video. If you have any comments, questions, or concerns, please leave them down below, and I'll get back to you as soon as possible. And I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe, because I'll be covering it all along the way with a legal focus. It's your Friday. I'll see you in the next video. Okay, bye.